Hello, everybody. This is Samantha from the law offices of Samantha Wolfe, and I'm here for this month's virtual seminar. So thank you so much for joining us. We always appreciate when our clients and referral sources jump on to listen to one of our seminars. I'm going to go ahead and share my screen for us. I'm excited about today because it's been a minute since I've gotten to talk about this topic. Let's see here. So I can't take credit for this very awesome title. Today's title is called Secure the Bag, Mastering Secure 2.0 for Retirement and Estate Wins. We've done presentations on Secure before, but it had been a little while, and I thought it was worth a refresh because I'm seeing more and more clients ask questions about retirement planning and how best to plan for retirement. So that's what we're going to talk about today. This is just our mission statement. One of the reasons that I always like to do our monthly virtual seminars is because I do think it's important for our office to inform you of new law changes, of what's happening in the law, of what we're seeing at our office, and ways that we're addressing our clients' needs. So thank you again for joining us. We really appreciate it. We do post all of our videos on our YouTube channel, which you can access on our website and through YouTube. So feel free to check out our other videos. What is Secure 2.0? So today, like I said, we're going to be talking about Secure 2.0, and the changes that it made to our clients' retirement accounts. So Secure 2.0 came after Secure. So these are all things that have happened in the last 5 years that we're seeing changes in how our retirement. You as a client may have experienced some of these changes when you're looking at your RMDs, what to do every year with your retirement accounts. And our financial advisor friends obviously have seen some changes in how they have to handle their clients' retirement accounts. Secure 2.0 was passed in 2022, and this law kind of built on the original Secure. It absolutely did. And what was confusing about Secure 2.0 was that Secure had passed, we'd gotten proposed regulations, and then before we even got the final regulations, Congress passed Secure 2.0. So they took the opportunity to adjust some of the retirement rules, and that's what we're going to talk about today. So the whole goal was to improve retirement saving options and provide some flexibility. Key goals were for increasing retirement savings. Now we're going to talk about what that actually means for our clients, but that was kind of how the bill was rolled out and what they were claiming the goals were for it, is to provide more control over withdrawals and contributions for clients, for taxpayers, and it was to enhance options for passing assets to different heirs. Now, why does it matter to our clients? And believe me, this is one of the biggest legislative changes that we've seen since I've been practicing law. And why it matters to you is because it does help you avoid certain penalties on required minimum distributions. Those are what we call our RMDs. So RMDs are the amount that every IRA owner has to take out every year once they reach a certain age for traditional IRAs. So we're going to talk about the penalties that come into play with RMDs. The Secure 2.0 was offering more ways to contribute to retirement accounts. It's providing strategies for tax efficient wealth transfer, and it supports legacy planning with updates to Roth and other retirement accounts. So many of our clients, whether it be teachers, physicians, anybody who has a 401k or an IRA, all of these new rules impact our clients. So it's worth talking about. And of course, I love talking about taxes and the changes that we've seen. So I'm happy to chat about this. So let's talk about what Secure 2.0 did with the required minimum distribution age changes. So the required minimum distributions, like I talked about, this is the minimum amount that you must withdraw annually from your retirement accounts once you reach a certain age limit. So when I first started practicing, this age was 70 and a half. Once you reach 70 and a half, then you had to start taking your RMDs. Well, Secure changed that. So Secure changed it so that it was 72, and then Secure 2.0 immediately increased that to age 73. And that change came into effect in 2023. So you don't have to take your RMDs until you reach age 73, as long as you haven't started taking your RMDs. If you had already started taking your RMDs prior to Secure 2.0, then you're still going to be taking them after Secure 2.0. But anybody who hadn't reached age 73 was allowed to wait before they started taking RMDs. Now, Secure 2.0 also is going to increase the age all the way up to age 75 starting in 2033. So 73 now, it increases to 74 in a few years, and then age 75 in 2033. Now, this helps taxpayers, and I'm going to explain how it was proposed and what this actually means for clients. So why this helps our taxpayers is it does allow more time for your investments in your IRAs to grow tax deferred. So when you have an IRA, what happens is that you make contributions and you get a deduction when you make contributions for your IRAs, and then what's in the IRA grows tax-free until you have to start taking your RMDs. Roths are a little different. Roths are after tax dollars, you contribute them into a Roth, but then when you pull out of the Roth IRA, there's no tax. So when the RMD age for traditional IRAs increased to age 73, it allowed clients more time for those investments to grow tax-free. And in doing that, it provided greater flexibility in planning withdrawals and tax strategies. Now, I'll tell you realistically for our clients, I'm not sure that we're going to see a big benefit, because what you have to understand is that yes, they increase the age all the way up to age 75, but it means once you turn age 75, the amount, the RMD that you have to start taking every year is going to be larger, because you're older when you have to start taking it. So when I meet with clients, even though they might be age 73 or younger and they aren't taking their RMDs, sometimes we still want to have a conversation of, you don't have to because you're not 73 yet, but you might want to be taking distributions out of your IRA. And that's just because by waiting, it means when you actually start taking them, the annual amount will be a larger amount, which means that your adjusted gross income will be larger, because when you take an RMD, again, it has to be included in your income. So if you're taking a larger amount because you waited till age 75, then that means that there may be more tax because it increases your adjusted gross income. So you just want to make sure you're thinking of that. Again, it was kind of explained as a way to allow people to continue to let it grow tax-free for longer. But again, we have to understand that means that when you actually start taking your RMDs, it will be a larger amount. Now, the penalty reductions for missed RMDs. So if you're required to take them and you don't, pre-Secure 2.0, there was a 50% penalty on the RMD that you missed. Under Secure 2.0, they reduced that penalty to 25%, or even further down to 10% if you can correct it quickly and go ahead and take that RMD. So what you want to make sure is that you're always tracking your RMD deadlines so that you don't have to worry about penalties to begin with. And that's where I think it's really been so helpful to be able to partner with our financial advisors and our friends there who do investments, is because normally your financial advisor can automate the withdrawals, so that way you don't have to worry about missing an RMD and being subject to a penalty. Positive is here we did see a reduction in the penalties when you miss an RMD. We also saw under Secure 2.0 that they expanded some of the catch-up contributions. So what this means is that anytime you're talking about a contribution that you can catch up, it just means you're allowed to contribute extra amounts to a retirement account if you're age 50 or older. So under Secure 2.0, starting in 2025, individuals between the ages of 60 and 63 can make larger contributions to 401ks and similar plans. Key benefit there is it boosts your savings before your retirement account. And sometimes when you are younger and you're working, you might not make as much of a contribution because you might need those funds out of your paycheck. So the thought being that if you're 50 or older, you may want to increase those contributions so that when you retire, you have a larger amount that you can tap into. So under Secure 2.0, we saw expanded catch-up contribution amounts. We also saw some changes under Secure 2.0 as it dealt with Roth retirement accounts. So it worked in the way of an employer Roth contribution. Employers can now offer Roth options for their matching contributions, meaning that if your employer is going to pay a certain amount and you're paying a certain amount and your employer is agreeing to match you, it can now be certain Roth options can be on the table for those contributions. RMDs from Roth accounts starting in 2024, Roth accounts and employer plans are no longer subject to those required minimum distributions. And that matters because it does allow the funds to grow tax-free without forced withdrawals. So Roths are beautiful because it's after-tax dollars. So once you contribute, it grows tax-free, and anything you pull out of those Roth IRAs, you do not have to include the withdrawal in your adjusted gross income for income tax purposes. So it does matter as far as if you would decide to do a Roth IRA. It just means it's better for you when you withdraw the funds from that IRA account. Using charitable giving under Secure 2.0, so we still have our qualified charitable distributions, or our QCDs. These are direct donations from your IRA to a charity of your choice after you're age 70 and a half. So again, you may not have to take an RMD until you're 73, but starting at age 70 and a half, you can take an amount that you would want directly from the plan and allocate it to a charity. And because it never gets included in your adjusted gross income, you don't have to worry about paying taxes on it. And it counts towards your RMD without increasing your taxable income or your tax base. Now, the limit, you can now make a one-time $50,000 QCD to fund a charitable remainder trust or a charitable gift annuity. But the qualified charitable distributions is an amount that you can make every year, and it starts at a base of $100,000, but then it's adjusted for inflation. So in 2025, an individual taxpayer can make a qualified charitable distribution in the amount of $108,000, and that's $108,000 per taxpayer per year. So this really allows you to take a big chunk of your RMD, if not all of your RMD, and allocate it to a charity. And because you never have to include it in your adjusted gross income, you don't have to worry about paying tax on it. Remember, when we're talking about charities, and we just talked about this, I think, in our last seminar that we had, but we did a whole seminar on charitable giving, and one of the things we talked about is the problem with charitable deductions and charitable donations is that you can only take charitable deductions if you itemize, and most people don't itemize. They don't have enough deductions to itemize. So the beauty of this charitable qualified charitable distribution is you don't have to be itemizing, because again, it's not a deduction that you're taking. It's just that RMD that you would have had to include in your adjusted gross income never comes into your adjusted gross income. It goes directly to the charity, so you don't have to worry about it increasing your adjusted gross income. So that's the beauty of that, is that more taxpayers can take advantage of that because it doesn't require you to itemize. Now, when we're talking about Secure 2.0, we want to talk about estate planning considerations for that. So the first thing we want to talk about is passing retirement assets to heirs. So non-spouse beneficiaries must withdraw inherited IRAs within a 10-year period. That was the big change that Secure made back when it was passed in 2019, where it used to be that if it paid to an individual beneficiary, they could stretch taking that RMD over their life expectancy. And now under Secure, we know that only certain types of beneficiaries can do that. Spouses would be one of them. But if you're a non-spouse beneficiary that doesn't meet the other criteria to be an eligible designated beneficiary and get the stretch treatment, then you have to take it out within the end of 10 years after the date of death. You may want to consider Roth conversions to reduce that income tax burden on your heirs. Non-spouse beneficiaries, like we talked about, must withdraw IRAs within the 10-year period. Trust planning, when you think about trust, you want to ensure that trust holding retirement accounts comply with Secure 2.0 distribution rules. We're going to talk about that a little bit more to make sure that you aren't creating a taxable event. So there's no more traditional stretch IRA for most of the beneficiaries. Now, that being said, there still are some eligible designated beneficiaries who still qualify for the stretch treatment. So the Secure Act changes, the original Secure, the one prior to Secure 2.0, eliminated that stretch IRA for most non-spouse beneficiaries and replaced it with a 10-year rule. However, we do have some eligible designated beneficiaries. So the first is a spouse. If the beneficiary of the IRA is a spouse, they do still get the stretch IRA. So spouses, minor children of the decedent until they reach the age of majority would be able to stretch it over their life expectancy. Any disabled individuals, chronically ill individuals, and any beneficiaries not more than 10 years younger than the decedent, all of these types of classes of individuals would still be permitted to stretch the RMDs over their life expectancy. But if you don't fall into one of these exceptions, then you're stuck with a 10-year rule. Now, the benefit for those eligible designated beneficiaries is they can still stretch the payment over their lifetime instead of that 10-year rule. Gives them more flexibility, typically less taxes. Non-eligible beneficiaries, that would be most adult children, siblings, other non-spouse individuals. That would be anybody else other than a spouse, a minor child, a disabled individual, chronically ill individual, or anyone not more than 10 years younger. If you don't fit into any of those criteria, then you're stuck with a 10-year rule. Let's talk a little bit about trusts as beneficiaries. Let's give the pros, the cons, and some pitfalls that we run into when we talk about trusts being the beneficiary of any retirement accounts. So the pros, the positives of naming a trust as the beneficiary of retirement accounts is that it does allow you control over the distribution, which may be the most important thing. If you have a child that has creditor concerns, divorce concerns, you think can't handle finances responsibly, then maybe it's worth paying into trust, even if it means the tax liability might be a little bit more. So a pro of using the trust is that you can restrict or manage how your beneficiaries receive those funds. That might be helpful if you have a younger beneficiary or if you have a spendthrift beneficiary, meaning they're not financially responsible. It does allow protection from creditors. So if you can properly structure a trust, it can protect those inherited funds from creditors or divorcing spouses. And then lastly, the benefit of using a trust as the beneficiary in a retirement account is that it does consolidate management of assets under one entity. That way you don't have all these different assets passing outside of where you would want it to go. Now, there's always negatives, right? So the common pitfalls would be potential for accelerated payouts. So if the trust isn't carefully drafted, it might trigger a 10-year payout rule or maybe even worse. So you want to make sure you either are working with someone that has some knowledge and experience, or if you are an attorney, you want to make sure that you are very clear on what you want the provisions of the trust to be and have drafted it with extreme detail, making sure that you're paying attention to the different provisions. Now, when you name a trust as the beneficiary of a retirement account, it immediately increases the complexity and the compliance that you're going to have to fall under. So trusts must have specific language to qualify for that favorable stretch. And if you have a poorly drafted trust, it can cause unwanted tax consequences or can force immediate distribution. And then another pitfall is the ongoing administrative costs. So sometimes we'll have families that have named a trustee and the trustee is going to handle the RMDs. And so that might have an ongoing cost to maintain that, to maintain the accounting, and it does increase the complexity of the estate plan. So always ensure that if you are using a trust, it's a see-through trust or a conduit trust if you want to maximize the income tax deferral. And you want to make sure you're working close with an attorney who not only understands the estate planning concepts, but also understands the retirement distribution rules. And if you have an attorney that understands that, then you don't need to worry about these pros and cons because your attorney will make sure to review them with you. Let's talk about expanded access to 529 plans and the rollover options that came in with Secure 2.0. So starting in 2024, beneficiaries of 529 plans can roll unused funds into a Roth IRA. Now, this is a huge deal because so many people move to using 529 plans as far as investments for maybe children or grandchildren so that way they could set aside funds to pay for education. The problem is that sometimes our beneficiaries don't go on for more school. So there's no need to have a 529 plan. And so then what do we do in that situation? Because the only alternative is to withdraw and pay a penalty. So under Secure 2.0, they allowed up to $35,000 over the beneficiary's lifetime in this 529 plan to be rolled over into a Roth IRA. The 529 plan must have been open for at least 15 years before you can do this rollover into a Roth IRA. And this matters because clients sometimes overfund 529 plans. And then the question is, if we have somebody who doesn't use all the funds for education, then where do these funds go? We don't want it to get trapped in the 529 plan. It does offer a tax-free way to transfer wealth to children or grandchildren. Secure 2.0 also brought in new rules for employer matching contributions. So employers can now offer matching contributions to Roth 401ks instead of only traditional accounts. So again, positive change there. These Roth matches are taxable now, but grow tax-free. And this matters because clients may want to review an employer plan to maximize tax-free retirement savings, and it could provide greater long-term growth for legacy planning. So this is also a big deal under Secure 2.0. Now let's talk about surviving spouse rollover flexibility as it deals with Secure 2.0. Like we talked about, the surviving spouse is an eligible designated beneficiary, so they do have the ability to take the RMDs over their life expectancy. But one of the things that we saw was that surviving spouses now have an option to treat an inherited retirement account as their own in new ways under Secure 2.0. So spouses can delay RMDs until the deceased would have reached the RMD age, which again right now is 73, or they can choose to roll assets into their own Roth IRA. Why does this matter? It provides additional flexibility in timing those withdrawals, minimizing taxes, and managing those estate assets. And it's beneficial for estate planning involving blended families or multiple generations. Let's talk about Secure 2.0 as it relates to small business owners and retirement plans. So under Secure 2.0, it did provide increased incentives for small businesses to offer retirement plans, including higher tax credits, which would be a big deal for a small business. Additionally, starter 401k plans are now available for businesses without existing plans. And the reason that both of these things matter is because business owners can leverage these incentives to build retirement savings both for themselves and their employers. And estate planning for business succession may need to account for these changed retirement benefits. Automatic enrollment and escalation. So what changed? So new retirement plans must automatically enroll employees with contributions starting at 3% with an annual auto escalation of at least 1%, reaching 10 to 15 unless employees choose to opt out. Why does this matter? It does help build retirement assets earlier, which can improve the overall health of the legacy planning. However, we just want to make sure that we're balancing that with the fact that businesses may or may not want to offer that benefit. So again, anytime we have a positive, sometimes there are negatives on the other side of that. Clients nearing retirement should understand how these changes affect their contribution and long-term savings. The elimination of pre-death RMDs for Roth accounts. So starting in 2024, and this is after Secure 2.0, starting in 2024, Roth accounts within employer plans are no longer subject to RMDs during the account owner's lifetime. So again, why this matters is they continue to grow tax-free, making them ideal for estate planning. Who wants to pay any taxes? And if it's in a Roth IRA, we don't have to worry about any federal income tax there. Clients should also consider consolidating or converting retirement funds to Roth accounts to help reduce taxable RMDs for the heirs. So that's always a nice thing, not just for yourself, but on to the next generation. Long-term part-time worker eligibility. So part-time employees working 500 hours per year for 2 consecutive years are now eligible to participate in employer-sponsored retirement plans. And this matters because it does provide additional opportunities to build retirement savings for those who have irregular employment history, and helps clients with part-time work increase their retirement assets and plan for their estate. Here are some strategies for maximizing Secure 2.0 benefits. So the first is to delay the RMDs, use the extra time to let your investments grow. Now, again, on the other side of that, just remember that when you start taking your RMDs, it will be a larger amount. So you'll be paying tax on a larger adjusted gross income because those annual RMDs are going to increase. You want to consider Roth conversions because that reduces future taxable RMDs by converting traditional IRAs to Roth IRAs. And you want to optimize catch-up contributions, max out those retirement accounts, especially as you approach retirement age. I love questions. So let's talk about common questions about Secure 2.0. So the first question is, do I need to take RMDs from all the accounts? And the short answer to that is no, you can take aggregate RMDs from similar account types such as IRAs. Second question, how does this affect my estate plan? You may need to update beneficiary designations and or trust provisions to reflect the new rule. We have clients that might have listed a trust as the beneficiary originally, but now under Secure 2.0, because we're not sure about the payout with that, depending on how long the beneficiaries live and the terms of the trust, you may want to reconsider how you're distributing or who you're appointing as the beneficiary. So what we're trying to do is go back to our clients and say, okay, anywhere where there was a trust designated as the beneficiary, is that still what we want today? Or are there tax incentives for why we would want to change that? And then the last question is, can I still donate through my IRAs? Yes, you can. You can use those qualified charitable distributions, and that's always going to remain a valuable strategy for clients. Now, the next steps that you can take as our client or as a referral source is number one, you want to evaluate your retirement plan. You want to review those accounts with an attorney and your financial advisor, and you want to make sure you're identifying any opportunity where you can take advantage of the new rules under Secure 2.0. Number two, you want to update your estate plan. So make sure you have beneficiary designations, any trusts that would help you, and make sure that those legal documents align with what your overall estate plan should be and what changes you want them to have. And then number three, remember proper planning today can help secure a comfortable retirement and leave a lasting legacy for your family. So again, retirement accounts are such a beautiful asset because they do avoid probate with beneficiary designations. We just want to make sure we're properly planning for them so that our clients are withdrawing if they need to or saving it in the future if they would want to do that. Now, our office, you can always call and schedule an initial consultation. Our number is 717-655-2676, and we're located at 20 East 6th Street in Suite 206 in Waynesboro. Okay, everybody, that does it for today's virtual seminar where we were talking about Secure 2.0. I really hope you enjoyed it. I enjoy talking about it. And like I said, more and more of our clients are really seeing that retirement rules matter so much to their estate because such a large portion of their estate passes through retirement accounts. So we always encourage our clients to reach out to us. And again, we try to post all of our videos on YouTube, so you can check out next month's virtual seminar. We're happy you joined us. Thank you for being here. Stay well, everybody.